LLCs are a very odd case. HMRC has taken umbrage at what they consider is the incorrect tax treatment, and the intention seems to be deliberately to give rise to double taxation between the US and the UK. So HMRC is effectively saying, well, we know that LLCs are treated as transparent, but we are deliberately not going to follow that treatment. Now, that is a very odd thing for HMRC to have done, in my view, that cuts against really the entirety of the post-Second World War economic structure in which double tax is an evil to be avoided at all costs.
Welcome to the US UK Tax Talk podcast. You might have noticed our new studio surroundings today. And to christen this new episode in our new space, I'm delighted to welcome two guests today from Collyer Bristow, James Austen and Henry Lopes, who both sit as a partner and an associate respectively with me in our tax and estate planning team. We're going to look at the really key question in the US UK space of limited liability companies and the Anson case, this all-important case about how we in the UK tax LLCs. We hope you enjoy the episode. Henry, Jamie, good morning. Thank you for joining me today. How are you both?
Hello, Aidan. Really well. Good to be here.
Very well, thanks, Aidan.
Do you like the new studio we find ourselves in? It's a bit different. It's quite nice, isn't it?
Well, it's very smart, just like our offices.
I wish I had a globe and a gramophone in my office, but I don't think I have, unfortunately. Look, you guys have both come on today to talk about one of my favourite topics, and I think a favourite topic of both of yours as well, which is the issue of US limited liability companies and all of the delights that they pose for a UK taxpayer, I say in jest. We're going to look at a couple of different things over the course of this episode. One, what LLCs, as we'll call them, what they are, why they pose a potential problem for UK taxpayers, the way in which the UK tax authorities deal with people that have limited liability companies, and then finally, what solutions are available to people that have these LLCs, because it's a very common refrain for people to be stuck in a position and not feel like they have any out. Henry, I'm going to pose the simple and obvious question to you first, which is, what is a US limited liability company?
Well, an LLC is, I would say, somewhat similar to an LLP in this country, limited liability partnership. They are a very common piece of US planning. They're good for holding investments, property, etc. And for US purposes, generally speaking, they are tax transparent. They are look through. So that members of the LLCs are treated as owning those profits as they arise, and they are taxed accordingly on their personal tax returns.
The key being, though, that it is a company as opposed to a partnership in law. I should stress, none of us being US practitioners, all of this is caveated, as ever on this podcast, that we are not US practitioners. But the nature of that tax treatment for US purposes being one that is created as an artifice, as a fiction in US law, where a taxpayer is permitted to have a company treated as fiscally transparent for US tax purposes,
I'm not sure that the Americans would see it as any more artificial than opacity. It's just the way that the law treats these particular structures. In the US, there is a concept of a company which is fiscally transparent in a way that we don't have in the UK. But if you think about it from first principles, that's no more odd or unusual than the converse.
Jamie, what listeners are going to hear, or what viewers are going to see over the next however many minutes of this episode, is that the UK and the US don't always see eye to eye on the way in which the profits of an LLC should be taxed. So talk to those out there in podcast world about the complexity with the UK position on LLCs.
So this is a sort of a primary question, a first level question. It goes to characterisation. So where a structure of whatever kind exists somewhere in the world outside the UK, and the UK doesn't have a direct corollary of it, how is that foreign structure treated for the purposes of English law generally, or Scots or Northern Irish law for that matter, and for UK tax law. So the question of characterisation is absolutely fundamental. It's not unique to LLCs. We apply it to Liechtenstein foundations, for example. Any foreign structure that the UK doesn't match exactly has this question of how should it be characterised for UK purposes. It arises very acutely in the case of LLCs, because on the face of it, the LLC, we're told, is a company. The UK has companies. We know how to deal with companies. Companies are opaque.
Easy.
Dead easy, you would think. But is that in fact the right treatment? Because actually, as we know, the US treatment is that they are generally transparent and profits taxed on the participants as they arise. So is there not an argument that actually the correct UK tax treatment is similar? We have that concept too, as Henry said, in terms of LLPs, for example. What we don't have is that treatment generally as regards companies.
What we have here, Henry, is one of the most acute examples, in my experience in the US-UK tax world, of the risk of double taxation, because we have two countries that don't necessarily see eye to eye on how a particular structure is taxed. So just for those out there in podcast world, again, what actually is an issue with double taxation? Why does it cause problems for taxpayers?
Double taxation at a high level is paying tax twice on the same item being capital or income, between the two jurisdictions, leading to very high effective rates of taxation. So looking at what happens in the US looks at the LLC income and says that is the member's income as it arises. That is the nature of that income. HMRC disagrees. HMRC says no, the income of the LLC belongs to the LLC in the first instance. Then there is a process of change going on. And after that, income is distributed to the members, much like a dividend. So HMRC says, this is different income that's been taxed in the US, is in nature different, therefore we have a right to tax it. So you get tax in both countries.
Jamie, we have a double taxation arrangement with the US. We have an agreement, a treaty that says specifically where two countries want to try and tax at the same time, one should provide relief. Now, I'm saying this sarcastically, hopefully clearly enough, but you're going to explain to us why that doesn't always apply.
Yeah, I mean, the UK does have a very good double tax agreement with the US. It's been in force for decades. So it's well understood. And the UK has actually got one of the largest number of tax treaties with other jurisdictions of any country in the world. And the UK was at the forefront of developing double tax treaties of this kind, specifically to avoid double taxation issues of the sort Henry explained. What has happened in historical terms is that states have strenuously tried to avoid double taxation arising between them because it's bad for the global economy, and that means it's bad for both participating states to a double tax agreement. And ordinarily, you would expect that the UK and the US, as close trading partners and allies, would go out of their way to ensure that there wasn't double taxation as between the US and the UK. And ordinarily, they do, and the treaty works very well. LLCs are a very odd case because what seems to have happened is that HMRC has taken umbrage at what they consider is the incorrect tax treatment. And the intention seems to be deliberately to give rise to double taxation between the US and the UK. So HMRC is effectively saying, well, we know that LLCs are treated as transparent in the US, but we are deliberately not going to follow that treatment. And the consequence of which is that we in the UK are going to tax the company here. And because the tax treatment is misaligned between the two jurisdictions, you can't get a treaty credit in the UK for tax paid in the US. Now, that is a very odd thing for HMRC to have done, in my view, that cuts against really the entirety of the post-Second World War economic structure in which double tax is an evil to be avoided at all costs.
To take it one step further, if we were dealing with an arrangement that was very rare and occurred, 1 in a million tax returns, you might think, well, HMRC doesn't have the bandwidth to address this problem, and so they've never really dealt with it. But this is a very, very common issue between American and UK taxpayers. And the number of times I get addressed by clients that say, but surely they've worked out how to come to an arrangement subject to what we're going to come on to talk to you about case law. The answer is they have not come to an arrangement.
No, I mean, I should say that the tax treaty itself, as most of them do, contains a provision that says where two treaty states can't agree, the competent authority of those treaty states should meet behind closed doors as an entirely secret process, and should seek to resolve the double tax. We don't know whether that has happened between the UK and the US. We will probably never know. But if it has happened, clearly it hasn't come to any resolution avoiding double tax, else we wouldn't be here talking about this issue.
No. Henry, Jamie very eloquently explained why double taxation is an issue. Without wanting to take us down too much of a side path, we can also talk about triple taxation when it comes to LLCs as well, because sometimes the fact that the UK may treat an LLC as opaque and thus as what we would say a company means that we can have Americans who sometimes get into even hotter water if they bring their LLCs, quote unquote, into the UK with them. Do you want to tell everyone about the risk of controlling your company from the UK?
Yes. Well, HMRC, when it sees a company, it wants to charge corporation tax to it. And it will do that if it deems, or it can be deemed, that the location of central management control of that company is in the UK. It is irrelevant where it's incorporated, where its shareholders are based. It is the location where central management control occurs. And often with these LLCs that we see, the members that we're dealing with, there may be one of two, or even it might be a sole member LLC, in which case it does appear to be centrally controlled and managed in the UK. If that is the case, HMRC want to charge its corporation tax. So you've got a third tax to play with there.
I think that raises a preliminary question to that, which we should probably tackle quite early. When does this issue arise? When do we see it? Why are we, as English tax lawyers, getting all excited and upset about US LLCs? What business is it of
Sitting in our
ours?
nice English studio with our fancy parlour.
And a cup of English tea. So how this arises in practice for us, which we see commonly and increasingly commonly, is in particular where we have the participants in US LLCs who are tax resident in the UK.
And when you say a participator, we are, in common terms, you might say a shareholder, or we might use the word member here, but we mean someone who owns an interest in the company itself.
Exactly. And where that person is tax resident in the UK, it's that gives rise to the fundamental tax mismatch that we're talking about.
So if you are a person listening to this podcast and thinking, am I someone that needs to think further about this? Maybe I want to email Jamie or Henry to ask more information. Do you own an interest in an LLC? That prima facie puts you in the scope of double taxation if you're one of Henry's individuals that he's just talked about, where maybe you are the sole member manager of an LLC and you run that business out of the UK, then you may be putting yourselves in the scope of UK corporation tax as well, and potentially exposed to triple taxation without any relief against the other two forms of tax.
And I think we should note here that central management control is independent of your tax residency. You can absolutely be a member, manager of an LLC, be tax resident in the UK, and the location of central management control is outside the UK. It's the locus of where you make those decisions when they're made.
You are absolutely right. Well made. I don't want us to spend all of this podcast talking about central management control. I know we certainly could. I can see Jamie's eyes sparkling. But where I want to take us is to the narrative direction that this question has developed over the last 10 to 15 years, because it's not just enough to say, well, we have this risk of double taxation and everyone throws their hands up because no one knows what to do about it. We very much do know what to do about it, because there was a very influential court case that said precisely what the UK courts thought should be done about it. Jamie, why don't you tee up everyone into the wonderful world of Anson?
The question really is, Why do we have this issue? Why can't the UK just see its way clear to dealing with this appropriately in a way to avoid double taxation? And that is what Mr. Anson thought. Mr. Anson was a UK resident US taxpayer owning an LLC. HMRC tried to charge him unrelieved double taxation on his LLC interest. And Mr. Anson said, well, hang on a second, I've paid all my tax in the US and you're not having it. And HMRC said, well, we think we should. And it went to the first tier tribunal. The case was heard by a really wonderful judge, now retired, Judge John Avery Jones, a fantastic tax judge, one of the best. And he decided in Anson, in the first instance, that the appropriate treatment in the UK was for it to be treated as transparent, as it was in the US. Therefore, there was no issue. There was no double taxation. Brilliant, you would have thought, except it went on appeal. And it didn't just go on appeal once. It went on appeal 3 times, all the way up to the Supreme Court. And it's quite rare for tax cases to get to the Supreme Court. This one did, because there was an important principle of international tax. And the Supreme Court agreed with Judge John Avery Jones in the first tier tribunal and said, unappealable, top-level decision, that's absolutely correct. And the reason that the Supreme Court did that is because findings of fact are made at the first instance. The first level hearing judge is the judge who decides what the essential facts of the case are. And unless when he or she does that, it makes an error of law in the finding of facts, those facts as found at first instance are basically unappealable. So all appeal courts subsequently can deal with questions of law, but they can't overturn findings of primary fact. And Judge Avery Jones, in this case, found as primary fact that the income arose directly to Mr. Anson in his LLC, and that was the essential finding that enabled him to construe UK tax law accordingly.
So, a question for you, Henry. We have Mr. Anson. He has won. He has been victorious against HMRC, and he has been allowed double taxation relief. I pose it to you. Did HMRC, in good grace, acknowledge the success and thereafter accept that a UK taxpayer would simply be able to follow the case of Anson, and this case all went away? I kid, we're here 10 years later, that's clearly not happened, but what was HMRC's response to the Anson case?
At first, it was to go away and sort of lick their wounds and do a bit of thinking. They did that and put out a rather sort of soft guidance on it, saying it's incredibly limited to its facts. We accept the Supreme Court's decision, etc., etc. That got significantly beefed up in December of 2023. They updated their guidance to say 2 things, basically. One, noting what Jamie said, is that it's limited to a finding of fact. Findings of fact are open to every single case in front of the FTT, so taxpayers are not able to rely on a finding of fact at the FTT, which was later confirmed as not erroneous as a matter of law in the Supreme Court. Secondly, they just said they thought it was wrongly decided. They thought the FTT got it wrong. They differed in opinion on how Delaware law works principally. There wasn't so much disagreement on the LLC operating agreement, or at least they haven't published it, but they just say as a first issue here, the FTT got Delaware law wrong, and profits do not arise to its members in the first instance, they arise to the LLC. And in that guidance, they put taxpayers on notice that they want to relitigate this. Taxpayers can expect inquiries.
I mean, the thing, Jamie, that even I struggle with actually, and so I look to you as much, not as a host, but as a lawyer, I want your experience. How it can be the case that HMRC is handed this defeat, that their response is to go, well, we don't agree. And our view as the taxing authority is we don't consider it, and they've increasingly said over the course of 10 years, we don't consider that people can rely on this Supreme Court case. So can you talk to, one, the rationale, the ideology behind that stance, but then also the difference between a Supreme Court case and HMRC's view on the conclusion of that Supreme Court case?
Well, let's deal with that latter question first. Essentially, there isn't any difference. It doesn't matter whether a case is determined at first instance in the first tier tribunal or on appeal to the upper tribunal, or determined in the Supreme Court. For these purposes, they all state the law as found. The only difference is that, of course, with decisions of the upper tribunal, the Court of Appeal and the Supreme Court, those have binding precedent status. So subsequent first instance cases in the first tier tribunal have to follow those cases insofar as it's a matter of law. What HMRC is saying is, as Henry said, we don't agree with the finding of fact in Anson. We, HMRC, are not prepared to proceed on the basis of that finding of fact in other cases because we do not believe it was correct. So there's a thing here, isn't there? Well, two things really. One, why was this question a finding of fact? It's about law. It's about the correct tax treatment or the correct basic legal treatment as a matter of, in Anson, it was Delaware law, but it could be any state. It's a legal question, isn't it? An American listener to us might ask what the correct treatment of income arising in a US LLC is. So why are Austen Lopes talking about this as if it's a question of fact? And that's because in English law, any question of foreign law at all is a question of fact for the UK tribunal to determine. And in Anson, Judge Avery Jones had two contrasting opinions between which he had to choose.
Each party had produced an expert Delaware lawyer to opine on the correct interpretation of Delaware law.
Exactly. And because it's a question of foreign law, it's a matter of fact, as a matter of English law. He had to decide which one was correct, and that was a question of fact in Anson. So that is what happened, and that is what he did. I think admirably. Actually, his judgment is an excellent example of a clear, logical, thoughtful, accurate model decision. It's just that it went against HMRC. But what HMRC say is questions of fact in any given case are irrelevant in any other case. Whereas questions, a matter of law determined by the Supreme Court is binding. This whole Anson case turned on this one finding of fact by Judge Avery Jones in the first tier tribunal. And what HMRC say is, well, because of that, we can now challenge every LLC tax treatment in the UK because that finding of fact in Anson is not binding on us in any other case. That is a very rare thing. I've encountered it one other time in practice on a VAT case on the so-called builder's block for VAT input tax refunds, where a case determined something was so, and HMRC released a public guidance afterwards saying, well, they might say that, but that's not what we think. So it's rare that HMRC does this. Frankly, it's not a very good look, but it does occasionally happen, and it has happened here.
So what we end up with is a scenario in effect, and Henry, this is where you and I have certainly done work previously for people that come forward and say, okay, great, well, there's the Supreme Court case, but also there's this quite clear and abrupt HMRC practice guide. How do I cut through this? What we end up with are taxpayers who are, in essence, trying to answer the rhetorical question of how close is my position to the Anson position, because the closer that I can get my facts, both the operation of US law and the nature of the management agreement, the operating agreement, which are the two things that Anson was found on, the closer my facts appear to mirror the Anson position, the more likely I am to succeed in being Anson 2, in beating HMRC again on their turf, which they have said they want to do. So in terms of how this analysis works, we all around this table have had taxpayers come to us, clients come to us and say, we need assistance. Maybe their accountants have said to us, with this 2023 updated guidance, we recommend the robust underpinning of some analysis by lawyers as to the nature of the Anson Agreement. What is the process by which we look at a given case and talk to the strength of a particular filing position?
So I think it's a two-stage process. First is obtaining, if necessary, the correct legal opinion of the local jurisdiction in the US. On the off chance, if it's a Delaware LLC, we probably don't need to do that because we have the benefit of Anson's, which we can rely on as an analysis of Delaware law for the purposes of filing a tax return. It's different if you wanted to take a case or if it was coming before the FTT again. So first step is get local advice from a US attorney. And there's sort of two main questions that we pose that US attorney. Firstly, as a matter of your local law, do profits belong to the members of an LLC as they arise? And second, to what extent is your local law functionally the same as Delaware law?
Because it's not the same in every single state. Each state has their own LLC Act or their own LLC statute. We have seen, in our experience, subtle differences between the way in which one state will say this is how you interpret a membership interest. This is the way in which, maybe subject to confirmation otherwise an express term in the operating agreement, this is the way that state law applies. And it's in those very specific differences that often the pressure cracks open. So the value of that local law is imperative in forming an important analysis.
I'll just jump in there. I mean, absolutely imperative, Aidan. You're absolutely right. Anson could so easily have broken the other way against Mr. Anson. It was a very nuanced decision by the tribunal at first instance to say that the income should be treated as arising to the members directly. That finding was made on the basis of the information before the tribunal at that point. It could so easily have gone the other way. And what would appear to be minor differences in wording between Delaware law and the law of any other US state might be enough, in theory, to tip the whole treatment on its head. And so, as Henry says, Henry's absolutely right about essentially the questions we pose to the US attorneys we work with on this. The two fundamental questions are, is this income treated as arising directly to the members? And two, how similar is your law functionally to Delaware law? Ideally, the closer it is, the better. And that is certainly the argument we would be making to HMRC, particularly in a filing position, before anything has been disclosed to HMRC. So with the taxpayer's UK tax return, this issue will be explained. We'll come on to talk about that. And what can we say about it? Can that taxpayer maintain a filing position that the UK tax treatment should be the same as the US? And the closer the law of the relevant jurisdiction is to Delaware, arguably the easier that is for us.
So let's assume, Henry, that we've obtained that fulsome, detailed analysis and the advice back from the US lawyer has said, yes, functionally, state X's laws are similar and robustly similar to the LLC laws in Delaware. The second stage then is to look at the specific operating agreement in question, isn't it?
It is. So the local law advice gives us our starting point. We then look to the LLC agreement to see if that sort of starting point is enhanced, overridden, disregarded, whatever. What we find is a lot of US states will say things along the lines of, unless otherwise provided for in the operating agreement in question, this is the position. So we then go into the operating agreement with a fine-tooth comb, pick it apart, and determine how similar that operating agreement is to Anson. If there are any differences, whether we consider them to be material enough to change the nature of how income arises to the members or the LLC, and form an opinion based on that as to the similarity between the operating agreement we have in front of us and the operating agreement that was in front of the first-tier tribunal.
Because, for example, to take an example, it seems to be a fairly common theme in LLC operating agreements, this these overtures paid, this homage paid to the idea that the profits of the company are automatically attributed to the individuals. But you and I both know, and I think in fact it was even the case in Anson itself, that there's often language in an operating agreement that says, well, does a board have to sign off on the profits being allocated, or is any kind of board involvement actually, administrative in nature? Because the more that a board is signing off on profits being allocated to each member's account, the more it starts to look like a board of directors from a UK company perspective deciding to issue a dividend. And that is going to start to make it look more like an opaque separate tax entity. So again, much like with the state law, it's going to come often down to some quite nuanced analysis as to the way in which the profits flow through.
Exactly. We're looking for words like shall rather than may, things like capital accounts. And one thing that HMRC seems to have hung their hat on is the fact that in Anson, there was no requirement, or there was some ambiguity about how distributions of profits were to be made to its members. So we're looking at that sort of thing in great detail to determine whether we would expect to see that sort of wording in a company situation in the UK. And if we do see that kind of wording, that gives us pause for thought, let's say, a further reflection.
I think the thing to add is that in general, in our experience of US LLCs of whatever state, actually, the laws providing for LLCs are very flexible, as you would expect. LLCs themselves are very flexible. So the laws provide a really pretty skeletal basic framework explaining that such a structure exists. But a lot is typically left to the operating agreement to set out in each case how the owners of that particular LLC want that to be run. So we can't say that there are, universal hard and fast rules about the way LLCs work, because in theory, everyone could be different. Which is why, as Henry says, would appear on the face of it to be minor wording can actually make a very significant difference if it's thought that the board has to approve distribution of income to members. That looks very much like a dividend in the UK and would lean heavily on the side of treating that LLC as being opaque.
Let's say, for the sake of argument, that we've run through our analysis, we've judged that there is a reasonable argument to be made that this LLC or the taxpayer has a reasonable Anson filing position, because we've said that the state law is sufficiently similar, the operating agreement is sufficiently similar. I look to you, Jamie, now, which is the part of my notes where it says, what should taxpayers do? Historically, we know from practice that 10 years ago, or certainly up until maybe that December 23 guidance came into effect, the modus operandi, I think, of a lot of taxpayers, as supported by their accountants, would be to make some passing reference in their tax return in the white space, the sort of any other information box at the end, and that would be sufficient. And we're saying these days less so.
That is, I think, commonly what happened. And in fact, I would have said before the 23 updated guidance from HMRC, that would have really been the gold standard of any mention of Anson or LLCs expressly in a UK tax return would be treated as sort of belt and braces, because actually, I think for most taxpayers and their advisors in the same position as Mr. Anson, they quite reasonably thought that the law was settled, and really it was an unexceptional point and nothing need be said about it.
There was a Supreme Court case, you were entitled to rely on it.
Precisely. So did a lot, probably taxpayers, simply not refer to it at all and declare the income in the appropriate and what they believe to be the appropriate way? Yeah, I think probably in many, if not most cases, that may well have happened. If some taxpayers or their advisors were particularly risk averse, they might have mentioned Anson by name or referred to an LLC as such in a white space box with their tax return. But with HMRC's guidance in 2023, that landscape changed, really. And now it would be the most foolhardy taxpayer who wouldn't very expressly draw HMRC's attention to the fact that given income is LLC income and that the taxpayer is relying on Anson transparency treatment. And the reason for that is the statutory obligation of taxpayers in the UK is to make a return which is correct and complete to the best of the taxpayer's knowledge and belief on advice as required. And one of the ways in which that is done is to draw to HMRC's attention any point in your tax return at which your proposed treatment is at odds with HMRC's stated guidance. And really, it is an absolute requirement for a properly made return to say, now in the case of LLCs, I have an LLC, I'm returning the income as being transparent in reliance on Anson, on the basis that the facts of my LLC and that are functionally the same.
The million-dollar question here, and I acknowledge our bias as lawyers sitting around this table rather than being accountants or tax advisors, for example, is why are we arguing that a taxpayer should take legal advice on the merits of claiming an Anson position in their white space return before doing so, as opposed to, let me pose you the hypothetical that we have seen around this table, which is, well, if they inquire my tax return, then yeah, of course, definitely, I'll take the advice. Then I'll suit up. I'll ammo up at that point when they come knocking. But why spend the money up front?
So, in fact, that was precisely the question that one of our clients asked us to advise on, and we did give him the advice that it was necessary for him to bottom these points out now before filing. And the reason is this: taxpayers can adopt a filing position. You can file anything you want if you reasonably believe it to be correct. The difficulty you've got is that if HMRC disagree with you and disagree with the reasonableness of your view, you are potentially liable to conduct-based penalties. And those can be very severe. In the case of offshore tax, typically, looking forward, they could be 100% of the tax owing, which in some of these LLC cases that we have seen can be an awful lot of money. Now, I should say that is a pretty extreme example, and I would ordinarily not impossible, and I have seen that. So to avoid the risk of penalties arising for what HMRC consider to be an incorrect return, the taxpayer has got to be confident enough in the technical analysis that actually an Anson filing position is open to him or her.
The idiom I've used to Henry a few times in the last year or so has been, if you're the antelope on the savannah and you're being chased by the lion, you don't want to present as the slow, fat, old antelope that's very easy to be caught. You want to appear with an iron hide. When you declare to HMRC, you want it to be patently obvious to HMRC, do not come messing around with my tax return because I have already well taken the advice that I know what I'm talking about. Don't leave open the flank for HMRC to go, if we were looking to find a new taxpayer to take to court over Anson and want to, strike the new standard, don't let this client be the client you do it in respect of.
So it's not a question of if. We know that HMRC wants to take Anson 2. It will fight tooth and nail over the question of characterisation in the first tier tribunal in the next case. It is inevitable one will be forthcoming. As you say, Aidan, most taxpayers who don't want the time and stress and expense of being that case want to disincentivize HMRC from making them the tax case. One would think that the better prepared the case is, the more cogent the evidence provided with the tax return is, the less likely it is HMRC will think, right, we've got a ripe one here, chaps, let's go after this. So we know it is an inevitability that there will be another LLC tax case. We're going to do a separate episode on what to do in answer to an inquiry on LLCs from HMRC. There's a whole episode to go through about talking about that. Ideally, you, the taxpayer, don't want your case to be that case.
I mean, Henry, I think that point that Jamie made, I think, is an important one, though, which is when we are advising clients, what we're saying to them is, we think you've got a position and we think it's a reasonable position for you to rely on, and you should feel comfortable taking that position. However, you have to be prepared for the fight. You have to make a commercial judgment that if you go into this fight, one of three things is going to happen. And again, you and I have had discussions with clients about this previously. One is HMRC don't look at your tax return. Maybe they do, maybe they don't, but they will have the right to look at any tax return. If they look at your tax return, you're either going to have to take them to court because they're not going to relinquish it unless you succeed in beating them, or you're going to have to roll over and pay the tax. And so there is, at the end of the day, a commercial inevitability, I think, about the position, and we have to help clients make an informed decision.
Exactly. Just in this conversation is why I was thinking, why do we give this advice? And it is one word, it's penalties. That's what we're doing here. The tax will be what it will be to a certain extent. If a court finds that you have to pay it, you've got to pay it, regardless of our advice. But it's the penalties that we're insuring against. So it is tricky to go to taxpayers and explain why, because this advice is not cheap. It's an expensive and time-consuming exercise, because we do have to go line by line through every single LLC agreement that comes in front of us. We had a client with 8 of these agreements the other day. And I do feel very sorry for some taxpayers. You do get a total range of wealth here. Significant wealth. Well, never
modest. Modest incomes. But middle-earning Americans in the UK with LLCs that might throw off a few tens of thousands of dollars in any given year. Not vast amounts of money. Is it enough money to merit litigating the point through the UK tribunals and court systems? Possibly not in some cases. And those clients are in a really tricky position, because either they just roll over and accept unrelieved double taxation, which really sticks in the throat. It's objectionable as a matter of principle. Or do you say, no, this is something I'm willing to have a go on, and it's wrong, and that's great, but that comes at a cost.
But also, just to flip it round, and again, I'm going to be sarcastic in how I say this, and I look to your experience, Jamie, as a litigator here. The fact that there's not a lot of money at stake doesn't mean that HMRC is not going to be interested. So the taxpayer that goes, well, there must be loads of rich people out there. The HMRC has such few resources these days. They've got much better things to be dealing with. So back to my antelope discussion. Just because you're a small antelope and there's a lot of juicier antelopes sitting around you does not mean that HMRC will not still pursue you, and pursue you almost absent the rationale financially of doing so.
Well, what HMRC would say is, we have adopted an in-principle position which we will apply to every taxpayer, large or small. Our view at HMRC is no different because you're rich or you're not, or because this particular LLP generates a lot of income or it doesn't. LLC, I beg your pardon. So they would say, well, we're being admirably equal, exactly, in our treatment. Actually, it's so much easier for them if it's, if the LLC is throwing off, let's say, $20,000 a year, that taxpayer is unlikely to want to fork out many tens of thousands of pounds in legal fees to fight it in the first tier tribunal. It's probably an easy win for HMRC. It's when the numbers get bigger that HMRC will be facing more intransigent taxpayers who have an interest, a really large vested interest in really fighting it.
So sort of as we move towards the end of this podcast, I'm going to come to each of you in turn, but I'm going to come to you first, Henry, which is put your best politician's hat and tie on. Imagine this is now your soapbox where you get to speak to the global audience of millions who this podcast is going out to. What do you wish more people knew about this issue? What do you wish more potential taxpayers faced with the prospect of an LLC inquiry, or faced with the prospect of having to take this advice, what do you wish they would do?
Talk to their accountants in the first instance, who are then, I hope, got the good sense to come to us, and probably is sort of an informal email to say this is the position, without sounding self-serving here. I hope they come to us for advice because they need it. You simply, it's untenable for taxpayers to just not declare it and see if they can slip one by HMRC. I mean, for two reasons. That's not a complete and correct return. and HMRC will find out. They talk to the IRS all the time. That data is totally available to the IRS. I'm sure HMRC could just put in a request and they can get all, without scaring people listening to this, I'm sure they can obtain a list of all LLC member names.
No one's used the words AI yet, but
Not AI.
I was thinking about
well,
it.
the HMRC have a supercomputer they're very proud of called Connect. I don't know the extent to which that uses AI. I suspect not at the moment, but it is plugged into an awful lot of sources. And the UK does have tax information exchange agreements with the US. There is tax transparency as between the UK and the US governments. And yes, there is automatic exchange of that taxpayer information.
And so just going back to what I want people to think about, not all is lost. This HMRC guidance is just that. It's guidance. It's their interpretation of the law, which you're entitled to rely on as the way they intend to tax you. However, it is not the law. The law is cases like Anson and HMRC. The law is statutes. So you are entitled as a taxpayer to take a reasonable interpretation of the law as you are advised it is and file on that basis. So not all is lost here. There is a very unattractive proposal of double taxation, but that doesn't mean to say that you have to file on that basis.
And I'm going to come to you, Jamie, but sandwiching myself between the two, if you will, I will also say if you're reaching out to your accountants or your lawyers, insofar as you have the opportunity to do so, maybe think about doing it before you come to the UK. So for those that are maybe coming to the UK and have these structures in place already, restructuring or doing something to avoid coming to the UK in the first place, obviously is going to give you much more opportunity to plan. If you're someone who is already here and it doesn't have that opportunity, or maybe you're here, but maybe you're still within your foreign income and gain regime, maybe we can take advantage of that, then sure. But let's try and speak to those people that are still in the US and have not yet come to the UK, because you definitely have the opportunity to do something about it.
Yeah, I'd endorse everything both of you say, and pre-residence tax planning for everyone, not just our American clients, but anyone coming to the UK is absolutely paramount. It gives us best opportunity to sort things out in advance to minimize tax issues like double taxation.
To cite the phrase of one of my fellow podcast hosts and people in the space, Richard Taylor, it's always better to prepare than repair. Jamie, from your perspective as a litigator and someone with a lot of experience in HMRC practice, from your perspective, what is it you think more people should know and what do you wish more people did?
What I wish they did is very easy. Have all the relevant papers. We have one client who has an open inquiry into his tax returns on an LLC issue where he can't find the operating agreement. And HMRC's position is, well, if you can't provide us with your actual operating agreement, what we will simply do is to apply HMRC's guidance on LLC operating agreements, which is to say that they're opaque. Thank you very much. Case closed. Pay the tax number next, please. The difficulty for us is to make the arguments in a case where we don't have all the facts, where it's very likely, actually, if we did have all the facts, they would be very positive for this client. So have your papers. Don't lose your operating agreement, or file it in some lockup somewhere back at home. It's a really crucial piece of evidence that we need. I would agree with Henry's point. Hope isn't lost. For what it's worth, my view is that the first tier tribunal and the Supreme Court got it right in Anson. I think that is English law and UK tax law. I think there is a very high chance that further tribunals and courts will follow that approach. Certainly with a Supreme Court decision, there is enormous, significant sort of emotional pressure bearing down on any judge to go along with it and not to find the contrary. The first tier tribunal judge who, when hearing the next LLC case, says, well, I know the Supreme Court said that, but that's not what I'm going to do. That will be a very brave judge, and judges are not usually known for being desperate to depart from high authority. So I think there are very good prospects of the next LLC case also going in favour of taxpayers. It may well be that it's one of our clients, one of our existing clients who is that case, in which case we will know first, and hopefully we can have an update podcast on that once we know the result of it. We can share that with the world.
I suspect if we're going to take away one lesson from this episode, is that even if you stick your head in the sand, HMRC will find you there.
They will. And that raises one thing that I was going to mention on taking the filing position, and why it is that we think, all of us around this table, that the white space wording is so important. So we talked earlier about the importance of avoiding penalties in having the correct and complete white space wording, referring to the LLC, referring to Anson, and I would say including a copy of the operating agreement, ideally, possibly with legal opinions from the relevant US jurisdiction and conceivably ourselves. And penalties is the major commercial driver for that. But there's another point as well that I wanted to make, and that goes to time limits for HMRC to be able to inquire into the return. So normally, HMRC can only inquire into a return within 12 months of its filing. That applies where everything that the reasonable officer needs to know is provided to them within the return or in the white space wording. If it isn't, then HMRC are able to make a discovery assessment, which has an increased level of time. In a normal UK context, that's at least 4 years. In an offshore context, that's 12 years in every case. So it means that if you put a tax return in this year, and you don't include all the information that an officer would need to know about your LLC, you could be hearing back in 12 years' time saying, well, actually, you didn't pay the right amount of tax, we think, in tax year 25, 26. And we'll have that, thank you very much, plus interest and potentially plus penalties.
So in effect, play your cards face upon the table.
Play your cards, which in my view with HMRC is always the right thing to do. It's never okay in the modern world to try and hide things from HMRC. It is always best to play things with a straight bat. If you have a sound filing position, tell them so. Explain why. Give them the documents that they need to be able to see that for themselves. Don't deluge them with irrelevant materials, burying a reasonable one in the middle of them. Just give them what they need to know. But make sure it's enough that they have everything they would need to know. And then you're protected and they can't make a discovery assessment against you.
I mean, I guess the question for you, Henry, the last question. Do you think we've scared everyone enough yet? Do you think everyone's going to be turning off this podcast going, go on, I feel much better after all of that?
I hope everyone was trembling at fear about the 20-minute mark and is now going to sleep incredibly well.
Out of the darklands up into the sunlit uplands again. Jamie, Henry, thank you so much for joining me today. Not only to talk about a really interesting topic and one I've wanted to do for a long time, but also in my new wonderful podcast space. It was very generous of you to give up your time. If people have questions, where can people find you?
Well, Aidan, you tell you tell the world where we can be found. We are all working in the tax and estate planning team at Collyer Bristow. Our contact details can be found on the firm's website and may be included within the comments section on this chat.
I'm sure it doesn't seem like it's outside the realm of possibility to do that. Jamie, Henry, again, thank you so much. And to you, the listener, we'll see you next time.
Thanks, Aidan.
Thank you, Aidan.
Thank you for joining us today on the US-UK Tax Talk podcast, and my thanks to James and to Henry for joining me on this episode. A reminder that we're now launching episodes monthly on the first Wednesday of each month, so make sure to like and subscribe, and therefore you won't miss an episode. A reminder also to check out Collyer Bristow's YouTube page, where you can catch all of our most recent episodes in video format. Thanks again for joining. We'll see you next time.